took advantage of those kids without even being worried that someone else was going to notice it. And you did it in the sneakiest, slimiest way possible. You touched them when they were sitting on your lap. How disgusting is that? How disgusting are you?
That was the blunt condemnation from a judge as she sentenced a former substitute teacher for sexually assaulting multiple young girls. Crimes prosecutors say he engineered by intentionally choosing to work in classrooms filled with young children. With this guy now behind bars, we're going to break down all of the details of this truly disgusting case. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Hey everybody, this is another Law&Crime legal alert. Did you know that children are being diagnosed with serious conditions like type 2 diabetes and non-alcoholic fatty liver disease, and the research is potentially linking ultra-processed foods to all this? Yeah, well, Morgan & Morgan, they're stepping in to fight to hold these food companies accountable. With decades of experience fighting large corporations, they're ready to stand up for the families who deserve justice. So if your child under 21 has been diagnosed with type 2 diabetes or fatty liver disease, then visit www.forthepeople.com/food or scan the QR code on screen to learn more. A former Oakland County, Michigan substitute teacher will now spend at least a decade in prison after being convicted of sexually assaulting multiple young girls, with prosecutors revealing that he deliberately chose elementary school to prey on children. Right, that's where he wanted to work. 61-year-old Timothy Allen Daugherty was sentenced on July 8, 2025 to at least 10 years in prison for assaulting girls that were as young as 9 years old at Spring Mills Elementary School in Highland Township, Michigan. And this is a case that has exposed systemic failures. It has left families grappling with lasting trauma, with one mother telling the court she is haunted by her decision to send her child to a school where she had to face her monster every day. This horrific nightmare began back in April of 2024 when multiple girls came forward and reported that Daugherty had touched them inappropriately. And concerned parents even contacted a local news station, WXYZ in Detroit, to voice their concerns. And the Oakland County Sheriff's Office launched an official investigation into this. And now, 1 month after the investigation began, so this is May of 2024, a board meeting was held at Milford High School, which according to WXYZ actually had nothing to do with the investigation in Daugherty, but that did not stop parents from expressing their frustration. And that is when things got tense in a hurry. At that point, Daugherty, who had been working for the school as a third-party contract substitute, had already been removed from classrooms. But furious parents, they demanded answers. And now, the Huron Valley School District released a response to the allegations, saying, "The Huron Valley School District takes any allegations we receive seriously, and we diligently follow all school policies and procedures. The safety and welfare of our students and staff remains our top priority." So prosecutors, they ended up charging Daugherty in October of 2024 with 6 counts of criminal sexual conduct in the second degree, which, by the way, punishable by up to 15 years in prison. Okay, now before I go any further, I want to bring on a special guest to help break all this down, somebody who unfortunately has a lot of experience in this area of law. Dan Schorr, former criminal prosecutor, municipal inspector. Dan, thanks so much for coming on. And by the way, for people who don't know, you have a book coming out about this very topic. Well, about not this story, but about this very, unfortunately, a topic that we cover a lot here on Sidebar.
Yeah, I'm a former sex crimes prosecutor, and I investigate sexual misconduct at schools now. So I wrote a novel called Open Bar that comes out August 12th that is about a child sex abuse scandal at a school and all the toxic fallout that happens. People can learn more about it by going to Substack and searching for me, but it definitely covers a lot of these issues based on my experience investigating these matters.
There you go. Okay.
And again, Substack, you can find me. I have a lot more information there.
Well, you are always a wealth of information, and I'm always so happy to have you on. Let's talk about this. So prosecutors say that this guy chose elementary schools to prey on children. How difficult is it to prove predatory intent in cases involving child sexual assault? I mean, we could put 2 and 2 together, right? We can make that an assumption, but for a prosecutorial point of view, how difficult is it to say he deliberately went to this school to essentially target young victims?
That is difficult to show, but I do think it's more of a minor issue than what they actually did while they were there. I think the predatory nature of it is important in order to try to weed out other future people who might also engage in such misconduct. So you will know warning signs, maybe in interviews, what to ask about, in background checks, what to look for. But for this specific defendant, once he's arrested, once he's being prosecuted, then it's less about the predatory intent, because when an older person is touching an underage girl, intent is not important. It is a statutory crime where it's not based on consent. It's based on the fact that they're underage, and you just per se, you cannot touch someone who's underage, especially when you're a teacher.
Would you say that in your experience, the perpetrators here may go, this is so disgusting, but I have to say it, they target young people because they might not recognize what's happening and there's a less chance they report it?
Absolutely. And also I see in a lot of the cases I've investigated and prosecuted that the offenders target specific children who they think are less likely to report it. Maybe they don't have as much of a support network, or they have other issues in their lives. And some of them, I can't speak to this case specifically, but I see it a lot where the children are coming to a teacher for help with something, and the teacher grooms them and takes advantage of them over time, when someone who had a bigger support network might tell someone else. And a lot of people who are repeat offenders, they know who to target. I see that a lot, and it's very sad.
Is it tough to corroborate these cases when you have young victims? How do you corroborate it? Is it literally at a trial you have to put these young children on the stand? And then what do you do next?
That's a great question, and it's really challenging. I've prosecuted cases with children as young and younger than these children. And first of all, this type of crime is almost always done in private, because that's the very nature of the crime, where a teacher gets a student alone who's underage, touches them inappropriately. And cases that involve touching, you're not going to see forensics that you would look for in other types of sexual misconduct, such as evidence of penetration or semen or DNA, things like that. So these cases are really difficult if they involve touching in private. There's no forensics. But what do we look for? We look at, first of all, cross corroboration. If multiple students are saying that the same thing was done to them, then that could be cross corroborative. Also, who did someone talk to? Very often people, even kids, they don't report it to authority figures because they're afraid of getting in trouble themselves, but they might have told a friend about something, even if it's a general comment, telling a friend, this teacher makes me really uncomfortable. And that could be corroborative also of something happening. But ultimately, as you talked about, often if you go to trial, you need to have the kids, and they are kids, on the stand testifying. And that can be re-traumatizing. That can be extremely scary. And I've had to prep kids to do that before they testify. And it's very challenging.
This guy worked as a third-party contractor. What are we talking about in terms of background checks, oversight, to know who we're letting into our schools?
Right. So usually a school, if they're making a hire, they're going to do their own background check. Usually they outsource that to a background check company. But very often when they're contractors, they rely on that contractor to vet the people that they're supplying as substitute teachers or other positions. So the question would be, what kind of background check was implemented? But sometimes background checks just don't find information that's helpful and that would stop someone like this from being assigned to a school. For instance, if someone had never been arrested, if they never had a civil suit, if they never gotten in trouble at another place of employment, if they never put anything disturbing on social media, then a background check wouldn't find if they just have this secret proclivity that isn't publicly known. Nevertheless, background checks are extremely important when schools are hiring people or for third-party contractors.
You think 10 to 15 years is sufficient for a charge like that, even if that's, the maximum that's allowed under the law?
It does. Look, anyone going to prison for 10 to 15 years, that's a serious incarceratory sentence. But it does seem on the lower end of what I've seen from other cases when someone has sexually abused multiple people. But this judge went through the whole trial, heard all the evidence. So definitely the judge is in a much better position than we are to say what's appropriate at a sentence. And at the sentencing, the judge certainly was very stern with this defendant and took it very seriously.
Let's talk about that a little bit more. So Daugherty appeared for this preliminary hearing on October 23rd, 2024, where Fox 2 Detroit reported that 3 children took the stand to testify about what he did to them. And the outlet says it was not allowed to record the minors' testimony, obviously due to their ages and the horrific nature of the accusation. So we don't know really what exactly they testified to, but what we do know, however, is at the conclusion of that hearing, Daugherty's case was, quote, bound over. It was sent to trial, and a decision that was met with great disappointment from Daugherty's attorney, Roy Kassar. He told Fox 2, the three individuals liked this teacher. They all hugged him and said everyone hugged him. All the hugs were done in the classroom. Some of the hugs were in front of the other teachers. It wasn't until one of the other students found or talked to her mother, who said it might be inappropriate, that all of a sudden they started to think this may have been inappropriate touching. Now, despite his attorney's defense claiming that the incidents were merely innocent hugs, the jury saw through it, and they convicted him in May of all 6 counts of criminal sexual conduct. And following the guilty verdict, Oakland County prosecutor Karen McDonald issued this statement about the case, quote, Timothy Daugherty victimized the children he was supposed to nurture and protect. Parents expect schools to be a safe place for their children, and children should never have to fear their own teachers. Coming forward is never easy for victims, especially children. Thanks to them, Daugherty won't be able to harm another student. And at his sentencing on July 9th, Timothy Daugherty stood before Judge Jasmine Poles of the Oakland County Circuit Court, who delivered a blistering condemnation of Daugherty's actions, even calling him downright disgusting. Now, we're going to get to that, but first, how significant is it that you had 3 children who testified during the preliminary hearing? I mean, I know they have to testify at a trial. Preliminary hearing, they have to?
It depends on the state law. I assume that the prosecutor would have had them testify if they didn't feel it was necessary, because prosecutors generally don't have, especially boys and girls who are underage, testify unless it's needed. So They must have felt it was important to keep the case going and to move forward to the next stage.
What about the defense? These are innocent hugs. The children liked the hugs. Maybe they even initiated the hugs. How do you differentiate between innocent physical contact and crime?
That's an interesting question. And what you just described, I wouldn't be surprised if that's true, because many people I've seen who are child victims of sex crimes, at the time of the abuse, they do see their abuser as someone who is a friend, someone who's supportive, and they may like that person, and they may not recognize, because they're young, because the other person's an authority figure, they may not recognize the horrific nature of the sexual abuse until years later. So that's part of the grooming process, where someone who's in authority, in power over underage people will take advantage of that and befriend them, and then start with hugs and then move on to other kinds of touching. And there are a lot more worse kinds of touching than hugs that were alleged here that led to this conviction. No one is being tried in court for hugs or sentenced to 10 to 15 years for hugs of children. So there was much more than that that was alleged and proven beyond a reasonable doubt. But certainly that's part of the grooming process in many of these cases. And
if other teachers had witnessed it, does that hurt the prosecution's case?
I don't think it really does one thing or the other, because, again, part of grooming, especially of underage people, is engaging in what would be seen by a third party as innocent type of physical contact, but then in private, escalating it to another level. I've seen that time and again in many cases that I've prosecuted and investigated. So it would not surprise me, because I've seen it elsewhere, if a teacher did do what looked like innocent hugs in front of other people, but then in private used that boundary blurring behavior to then take it to the next level and engage in what here was proven beyond a reasonable doubt, which was sex abuse that was extremely disturbing.
So during the sentencing hearing, Daugherty's defense team pushed for a reduced sentence, citing his cooperation with investigators, pointing out that many other children had interacted with him without reporting any kind of issues. Take a look.
I want to reiterate, Your Honor, that Mr. Daugherty was working as an elementary school teacher for 12 years. And over that span of 12 years, he was in contact with over 1,000 children. Nobody from any other school came forward. There were no other allegations from any other school. He never made any threats. There was never any victim asportation. There was no secrecy, and he fully cooperated with the investigation. Like I said, he has a supportive and loving family who are here and will continue to support him. So I'm asking, Your Honor, to sentence Mr. Daugherty to the low end of the sentencing guidelines at 36 months. Thank you.
But prosecutors, they pushed back, and they pushed for the maximum sentence, arguing that Daugherty's crimes went far beyond typical sentencing guidelines.
Defendant Daugherty was
uniquely aware of his sexual proclivity for children. He is the one who knew. And he chose to work at an elementary school. The children trusted him, they liked him, they hugged him, and he repeatedly sought sexual contact. And so I stand before you arguing that the people assert that the advisory guidelines in this case are not appropriate, and we ask this court to exceed them. Thank you very much.
And prosecutors requested 10 years, so the maximum sentence that the court could impose. Dan, back to you. How common is it for the defense teams to argue for reduced sentences and it being effective? Because, you know, you talk about these crimes and you would think somebody, a layperson, would look at it and say the judge should throw the book at these people, right? But is there times when mitigation does weigh in the defense's favor and the judge is convinced?
Well, I see a lot of defendants and their attorneys say, well, look at all these other people who I interacted with without any problems. And I never find that to be a powerful argument. That's as if I was walking down the street and I stole your wallet. And then as a defense, I said, well, I'm going to call all the other people on the street whose wallet I did not steal to show that I walked by them without stealing anything. And that's not really helpful information. But I see that in a lot of cases. I investigate sex abuse cases, sexual harassment, and a lot of times the defense is, well, here are all these other people who I did not offend and I did not act improperly with. But that's not what this case is about. It's about these children. And here you have multiple children who testified, and they did so persuasively. That's what led to the guilty verdict here. So I think that those arguments are standard arguments, but it's very rare for them to be convincing and helpful, I think.
Can you explain how sentencing guidelines generally work, maybe in Michigan, for criminal sexual conduct? Are judges bound to follow them strictly? Can they deviate?
I'm not sure about the flexibility there because I was a New York prosecutor and I prosecuted sex crimes there, but certainly the standard way is that there's usually some range of sentencing so judges don't have just carte blanche to do whatever sentence they want. And it's really important because we want some standards in society. It's important in a free and fair society to have some kind of consistency so you don't have one person who commits the same crime get a wildly different sentence than someone else. But you do want some flexibility because you want the judges to take into account certain exacerbating facts or mitigating factors that maybe lessen the offense. They don't excuse the offense, but they might make a lesser sentence justified. So usually there's some standard range and then there's some flexibility. And when I was a prosecutor, I would often make those arguments to a judge about what I thought was the appropriate sentence, and the defense attorney would argue for a much lesser sentence, and the judge would then make a decision.
So this sentencing hearing reached its most emotional moment as parents delivered gut-wrenching victim impact statements, laying bare just the lasting trauma that Daugherty inflicted on their families. In fact, one mother, her voice breaking, expressed guilt.
I made her go. The guilt I feel for making her go to school and facing her monster is eating away at me. Timothy Daugherty used an elementary school as his hunting ground for his assaults. Once I learned of what happened to my daughter, I allowed her to stay home many times, as I did not know how else to help her, to make her feel safe. Her schooling was affected badly. She missed a lot of days, 35 plus. Her grades dropped. She didn't sleep well. To this day, she still wakes up with nightmares and comes to my room in the middle of the night to feel safe. She gets angry, frustrated, sad, and fearful so easily now. It's hard for her to trust others, as he was supposed to be someone she trusted. Our anger will linger on. Our guilt of not being able to protect so many children, including our own, will haunt us.
You know, Dan, hearing parents express their pain, guilt, anger, mixed emotions, how important is that for sentencing? How important is that also from a human point of view, healing and saying this in an open forum?
Yeah, well, first of all, the victim impact statements are very important for sentencing because, again, there's mitigating factors, there's other factors that make a sentence, maybe you need a harsher sentence. And for someone to be able to tell the judge, this is how it impacted me, or this is how it impacted my child, that's really persuasive sometimes for a judge to be able to hear the real human impact on it. That's not just about an indictment and words on a page, that there are real human beings here. And for that mother, it's heartbreaking talking about feeling guilty, sending your child to school where they were abused. And whether, I'm sure the parents had no idea this was going on, but there's always going to be that feeling of putting your child in harm's way. And remember, when kids are sent to school, kids are told, behave, trust your teachers, listen to your teachers. If your teacher tells you to do something, you should do it. And that's often how these predators take advantage of students, because they know they're there and they're told to listen to your teachers and behave. So if you're young and you don't know what's right or wrong, and your teacher's blurring the boundaries of appropriate touching, that's really difficult for someone this young to really understand and also be brave enough and have the strength to report when they don't know what's right, what's wrong, and how they're going to get in trouble for reporting. So that's a big concern I hear a lot.
And then we heard from Daugherty, so the defendant, his turn to speak, and he delivered what could only be characterized as an attempt at an apology. It becomes a question if it's hollow or not.
I'd like to say I'm sorry for the situation that's involved with these children and all the families that are involved. Being the adult in this situation, I take responsibility, become a better person, and my approach to the children were never for harm, but being the adult, I should have realized that some of the things may have happened. So I take responsibility for that, and I go from there.
And that apology was not well received by Judge Poles, who immediately shut him down.
All right, so I don't really hear you taking responsibility. I hear you saying that I'm the adult here, so I guess I gotta take the fall for this thing. I get to talk now. You had your opportunity.
Yes, ma'am.
All right?
Yes.
You done?
Yes.
All right. So I sat here through your trial, and I heard all of the witnesses testify. And I can make my own independent assessment as to whether or not I find that their witnesses are credible. And of course, I make a motion. Your lawyer made a motion for directed verdict, and had I found that they weren't credible, I could have said, "Yeah, you're right. All of this, none of this should be here." But I said, "No, it's a question of fact for the fact finder. They're going to make a decision." And then the 12 people went back, and they made a decision that you sexually assaulted all of these children.
And by the way, her anger only grew as she dismantled his excuses piece by piece.
We all know what you did now because we heard them testify, and 12 of your peers found you guilty of it. So there should be no more confusion moving forward. Those children all testified truthfully and honestly that you put them in positions of sexually assaulting them, touching their body. They're children and you're the teacher. It's everybody's worst nightmare. You put these parents in a difficult position. You have their children being sexually assaulted.
And then came the judge's most devastating blow, accusing Daugherty of calculated deception.
So you knew exactly what you were going to do in that school, and you took advantage of those kids without even being worried that someone else was going to notice it. And you did it in the sneakiest, slimiest way possible. You touched them when they were sitting on your lap. How disgusting is that? How disgusting are you as you stand before this court?
So Judge Poles sentenced him to the maximum penalty of 10 to 15 years in the Michigan Department of Corrections. And despite being convicted on 6 separate counts of second-degree criminal sexual conduct, the sentences will run concurrently, meaning Daugherty will serve them simultaneously rather than back-to-back one after the other. The judge also ordered that he permanently register as a sex offender, and if he's granted parole after serving the minimum of 10 years, he'll be released under lifetime GPS monitoring, ensuring authorities can track his movements indefinitely. You know, Dan, we hear judges make statements. This one was a little bit different.
Right. This judge seemed very offended by the defendant's lackluster attempt to take responsibility, because that's often a factor at sentencing, is whether the defendant is taking responsibility. And he threw out words that seemingly in a weak way might have implied responsibility, but didn't really take responsibility. And the judge just clearly called him on it and said, "You're not taking responsibility. You're saying things that don't show that you understand the magnitude of what you did or how responsible you are." And there was one part where the defendant tried to speak again, and the judge shut the defendant down and said, "No, you had your chance to talk. Now I'm going to talk, and I'm going to tell you why what you did is so horrific." So this judge definitely did not take well the defendant's attempts. And, you know, if someone's going to take responsibility, I've seen this in court. Sometimes people try to take responsibility, but they do it in such a way that doesn't sound sincere. And judges don't like that for good reason.
I don't know if the judge was restricted I don't have a reason to believe this, but you could have, there was a possibility, I guess, you could have sentenced him to consecutive sentences, unless there's some prohibition under the law, which again I'm not aware of. But what would be the justification for doing it concurrently and not consecutively?
That's an interesting issue that comes up at a lot of these cases with multiple victims. And often it's the judge looking at the total time of incarceration versus what they're accused of doing. And if you're going to run 10 to 15 years concurrently, then you're talking decades in prison. And maybe the judge didn't feel that was appropriate for this crime. But a lot of it is also based on local state law, which can deviate based on the crime and based on other factors. Sometimes the judges look at prior criminal record. If someone didn't have any criminal record in the past, it's less likely that their crime is going to lead to consecutive sentences. So those are some of the factors that judges consider. But it's a huge difference if you get consecutive sentences and you're talking about when one's done, you're then serving the other. That's a huge difference than running them all concurrently.
So 10 to 15 years, chances he gets parole in 10 years.
Right. So he is, I believe, early 60s now, right? So he would be a decade older. Certainly he's never going to be allowed to teach again. There'll be sex offender restrictions on being around other kids. Usually that involves where they could live, where they could work, where they can socialize. So there'll be a lot of enforcement, hopefully, of that. Some states are better than others in enforcing those conditions, but that's why we have sex offender parole for people in every state in the country. And it's really important to monitor people so that they don't just fall through the cracks and are able to offend again easily.
And before I let you go, how effective is, I don't know, a lifetime of GPS monitoring, watching somebody, prevent the sex offender registry in preventing recidivism, in your opinion? Is this a challenge for law enforcement, or do you think that this actually does a good thing?
I think it's a good thing. I think that it's not something that is complete. And I think sometimes it gives people too much of an assurance. People think, well, if there's a sex offender near me, they'll be on the registry and someone will find out and someone will take care of it. And that's not true, because people don't always follow through with sex offender conditions they're required to follow. And different states have different levels of enforcement. So it's not perfect, but I think it is a good first step to have someone being monitored. Hopefully it also sends some reason for them to feel caution, for them to feel they're being monitored, and therefore they know that they need to behave in a way that maybe they didn't feel that way before when they weren't being monitored. So these are all things that make it more likely that someone won't offend again, but it certainly doesn't stop people from reoffending. Unfortunately, as you know, with the many cases you've covered, people do reoffend in terrible ways when they're on sex offender probation or parole. But it is one of the tools of many tools that law enforcement has to try to stop this behavior.
Dan Schorr, thank you so much for taking the time. Again, encourage everybody to pick up your book if they want to learn a little bit more about this. Thank you so much, as always.
Thank you, Jesse. It's always good to talk with you.
And that's all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. I'm Jesse Weber. I'll speak to you next time.